Two cases on the 9 a.m. docket for Wednesday, January 28th, 2026 are appeal number 127774, State of Kansas versus Jonathan D. Carr, and appeal number 127850, State of Kansas versus Reginald D. Carr. Court sets the following schedule for oral arguments. Counsel for Jonathan Carr will argue first and has 20 minutes. Counsel for Reginald Carr will argue second and has 20 minutes. The state has 40 minutes for argument. Jonathan Carr will present rebuttal first and has reserved 3 minutes for rebuttal. Appellant Reginald Carr has reserved 7 minutes for rebuttal and will go second. Counsel will enter their appearances.
I am Mark Henriksen from Oklahoma City, appearing along with Jason Belleville of Kansas on behalf of Jonathan Carr. We are present and ready for argument.
Good morning. May it please the court. Brian Pomerantz. I will be arguing on behalf of Reginald Carr.
Good morning, Your Honors. Alicia Meddy on behalf of Mr. Reginald Carr.
Brianna Harris on behalf of Reginald Carr.
We are present and ready for argument, Your Honors.
Thank you, counsel.
Thank you. May it please the court. Deputy District Attorney Boyd Ishwood on behalf of the state of Kansas, present and ready for argument.
Good morning, Mr. Short.
Your Honor, ready to proceed.
Okay, thank you. Mr. Hendrickson, when you're ready, please approach and you may begin your argument. And I will note that you reserved 3 minutes. Is that correct?
Yes, Your Honor.
Okay, thank you.
May it please the court, thank you for permitting an out-of-state lawyer to argue this case. My client, Jonathan Carr, appeals the trial court's decision in which it found it had no jurisdiction to consider sentencing Mr. Carr after this court had significantly modified his prior sentence. We acknowledge up front the government's argument that the trial court cannot modify or ignore an appellate court on receipt of a final mandate. But this case presents the exact occasion for the court to consider the exercise of statutory discretion by the trial court in imposing a sentence which, upon receipt of this court's mandate, profoundly modified the order entered by the original trial judge. As to whether Kansas law permits that, we have cited numerous authorities. For example, Collier and Clark, cited in the briefs, stands for the sensible idea that the recipient court, using your language, must implement both the letter and the spirit of the montage, taking into account the appellate court's opinion and the circumstances it embraces. These cases stand for the proposition that district courts have more than a ministerial function upon receipt of your mandate. If these cases do not support that broad authority, as I am urging, I think the Carr case gives this court an opportunity to correct what might otherwise be perceived as a flaw in jurisprudence. Both the appellants and the state have cited this Soto versus Kansas case, which holds that the mandate rule does not prevent a district judge from doing whatever is necessary to dispose of the case. Both sides cite it. We obviously think it means something different. But that is what we are seeking, for the district court to take the action necessary to conclude the sentencing in this matter. In 4 capital cases, the state charged 2 alternative theories as to each homicide committed. They were denominated.
Excuse me, counsel. Sorry to interrupt your argument. Before you get into the theory of error, what do you think in our Reginald Carr 2 or Jonathan Carr 2 opinions left a gap open. I mean, there was nothing explicit, would you admit, in the mandate that remanded the matter or gave instructions to the district court? Are you arguing it's all just implicit in the discrete theories that you raised in your motion before the district court?
Well, your mandate did not order a specific action to be taken by the court. On the other hand, your opinions in Carr 1 and then adopted in Carr 2 reversed 7 of 8 murders for which my client had a sentence. And it also reversed 19 felonies, non-capital felonies, as to Jonathan Carr. I don't really know the number as to Reginald, but it reversed 19. And so that has not been taken into account. And so a sentencing, and I intend to develop this in my argument, a sentencing that occurred in 2002 took into account 26 crimes that this court has found were invalid, and they were adopted as part of the government's evidence in its case in chief, which is a tactic, a common tactic, and it's probably a good one, and it saves a lot of time, but it runs a certain risk if a whole lot of your case in chief is gutted on appeal, and it was what was presented on motion, approved without opposition, as what you're using to convince the jury of aggravating circumstances exceeding mitigating circumstances, and that being and death being the proper punishment. Then you clearly have, this court has clearly gutted the state's case and set back a mandate. And it seems to me that the district court needs to make a determination under authority I'll get to in a little bit as to being the court of first instance in determining whether death is the appropriate case now, not based on the erroneous evidence that was presented in 2002 as determined by Carr in 2014 and Carr in 2022.
But when you talk about the erroneous evidence, that evidence still would have come in, correct? It's just that the convictions, were overturned, but the jury still would have heard all of that evidence, correct?
The jury would have heard that evidence, but it seems to me that the state's tactics and approach in this was what, for want of a better word, was piling on. The jury hears they've convicted, is told in the instructions that that they've been convicted of now 8 murders and 50-some felonies. And this court found that the way that was done was overbroad, that they had violated double jeopardy on 3 of the multiple counts, and that they had violated the law and on the sex crimes, and then multiple serious other felonies you found wrong. And so all of that was submitted in the government's case in chief, and this court, so far as I could tell, you do have what I'll call the boilerplate language, that you've conducted a review and determined that the aggravators exceed the mitigators, and that you find that the death sentence was valid. But nowhere in Carr 2 does it indicate that this court addressed the question that we're raising on this motion. You all gutted, reduced 26 felonies, 7 of them murders. And yes, Your Honor, the evidence would have come in, but surely a jury is impacted by the weight of 24+ additional serious felonies being part of the case, the state's case in chief, to try to prove aggravation.
But the conviction that stood talked about more than one person being, they did convict him, under the conviction that stood relied on the evidence of the other murders, correct?
Yes.
And it was the same jury that heard all that evidence that that sentenced him, correct?
Well, as to that, I don't want to not be able to make the main argument I came to make, but the problem with that, as a matter of law, is that the count that stood up, withstood your second review, is probably count 2. There's a little bit of dispute about that. And at the sentencing hearing on November 15th of 2022, '02, the court did not sentence him ever on count 2. And our position is that Jonathan Carr is in prison today on, apparently on that count, having never been sentenced in compliance with Kansas law. I'd like to develop that so that you understand exactly the point that we're making. But yes, that's the point that we're going at.
I'm struggling with what you were asking Judge Gehring to do at the district court on the remand. And he kept going back to the mandate. I mean, that's what he did. And the mandate is pretty clear. I'll just read from it. On January 21, 2022, on consideration of the remand and appeal, it is ordered and adjudged by the Kansas Supreme Court that the death sentence is affirmed. And he kept citing to that and citing to that. He says, where is it that I have any authority to resentence when the sentence is affirmed? And I'm struggling to see, sitting in his shoes, what was he supposed to do?
Well, apparently he, at that time, rejected the contention that we were making that Jonathan Carr had never been sentenced on count 2 because under Kansas law. And if I could explain about that just a moment.
Yeah, but how does he ignore what those words I just read in our mandate?
Not asking him to ignore it, but your statute says that the trial court, as the court of first instance, will look at the jury's recommendation as to death and will make a determination. Now, Judge Clark did that, but he did it based upon 27, as to Jonathan Carr, 27 matters that had been reversed and had been taken out of the cases, the state's case in chief and punishment. And so my client has never been sentenced in any open court in district court as to count 2. So our suggestion is that he's an unsentenced person being held in the state penitentiary on a case that was never announced for a judgment.
How does the merger doctrine affect your argument? Because they were alternative capital murder theories, correct?
The state filed 8 homicides, and somehow at the instruction and verdict phase, counts 1 through 8 were redenominated as count 1A and 1B and 4A and 4B, etc. How that happened is not clear on the record, but that's what happened. And then at the sentencing on November 15th, Judge Clark said you were sentenced to death on counts 1, 3, 5, and 7. He was silent about the even numbered counts. The even numbered count is presumably the one that has so far withstood Supreme Court review. And there has never been an announcement. Kansas law seems to require that, and it's never happened. And we pointed that out to Judge Gehring, and he said that he didn't have jurisdiction to sentence Jonathan Carr. That's why we're appealing, because we think that that was a mistake. This court has purported to affirm count 2, and presumably you meant what you said, but there has never been an announcement in the district court of a punishment on count 2. That being so, then it goes back to Sedgwick County for sentencing, which has never happened yet because he didn't follow your statutory or case law authority about announcing the sentence in open court. Did it merge? I don't think so. There was no commonality between them except the decedents. They seem to be going counts 1 and 2 as to one defendant, one decedent, and so forth. You know, in Carr.
They were alternative counts, right?
Yes, that doesn't mean they merged. They were alternative counts, but there's no evidence that there's no indication on the record that anyone ever presumed that they merged. You know, and I can't find a case that specifically says that what we're complaining of, the failure to announce, defeats the sentence. But you all, in Carr 1, in the Reginald Carr opinion, relied on U.S. Supreme Court doctrine and Stromberg and Yates to reverse 4 convictions because you said that a general verdict, which has both a valid and an invalid theory, cannot be used to sustain a conviction. And you reverse those. Well, I suggest to you that although my argument is not an identical twin of that, it's certainly a first cousin, because now you're presented with counts 1 and 3 through 8 having been reversed, 2 perhaps having withstood appellate review, and you have to decide, are we going to affirm count 1, which was reversed? Are we going to execute Jonathan Carr on count 1 that was reversed, or on count 2, which was never announced in district court?
But if 1 and 2 were alternative counts, doesn't the jury's death verdict attach to the single conviction and not to the discrete alternative counts?
Well, on the same day that the non-announcement of a sentence of death on count 2 did not occur, the same day, Judge Clark signed a journal entry of judgment that went ahead and denominated counts 1 through 8 and identified them as the crime that was allegedly being violated and the punishment of death. And for reasons about which I remain clueless, he did not announce a sentence of death on the even-numbered counts. The even-numbered count appears to be the one that withstood appellate review, and he has never been sentenced in open court as required by your law to do that. And that's a problem.
What do we make of what I understand the state's argument to be that begins with this notion of merger, that the alternative counts 1 and 2 were sort of merged into a single capital murder conviction. And then if we look at the journal entry, it does seem to track. I mean, there are 4 capital murder convictions, and they include each of the 2 alternatives and the sentence of death. Does that journal entry clarify any potential ambiguity in the pronouncement of the sentence specific to count 1 only?
In my opinion, Your Honor, it clarifies it. It clarifies it that there were 8 separate theories of murder. The jury found Jonathan Clark guilty on all of them, and for reasons that defy explanation, Judge Clark announced a punishment only on the even-numbered counts. And the journal entry you just referenced lists each one, counts 1 through 8, lists the crime that was violated and the punishment that was rendered. But he does not say that in open court. We cite the Hayes versus State case in the brief that says that for a sentence to be effective, it must be announced to the defendant in open court. We cite a statute that seems to make his presence mandatory. And in all due respect, that didn't happen. And so this court's going to have to determine whether it matters or not. It appears there's reluctance to continue this litigation, but in taking someone's life by the state, the I's should be dotted and the T's crossed. And I appear to be exhausting my time, and I thank you, and I'll be back in a few minutes.
What is the remedy that you're asking the court?
We believe that Jonathan Carr has never been sentenced, period, and that he is entitled to a sentencing as provided in Kansas law. Kansas statutory authority sets out how that happens. And I'm not asking you to presume what the outcome of that sentencing will be, but remand this for a sentencing as required, a sentencing that's never occurred on the murder count that it was affirmed. Order that remanded for a sentencing hearing, and let us have an opportunity to persuade Judge Goering of what we think the proper outcome will be, and the state will have its own opportunity.
But not necessarily, you're not asking for a new penalty phase hearing. You're asking for the district court judge to repronounce the sentence that you believe should be that was not imposed originally.
I don't think that we've briefed that or had to at this point. If we are remanded to district court, then we will seek all available remedies and Judge Gehring will make a decision as to what those are. I'm not prepared to foreclose a jury trial, but but whether that happens or not, there has to be there's never been a sentencing on count 2. So there has to be one in which, in which the current state of the case is presented to the court and a fair decision is made.
Any other questions of Mr. Hendrickson? Thank you. We'll see you back on rebuttal.
Thank you.
Mr. Pomerantz.
Morning again, Your Honors. I have reserved 7 minutes for rebuttal.
I have that noted. Thank you.
Thank you. As offensive as it may be to many, today is about procedure. I'm not here to argue or even discuss culpability, but rather the indispensable issue of whether due process was followed. Today we determine, as Mr. Hendrickson said, whether the courts have dotted the I in justice and crossed the T's in death penalty. They have not. The murders of Heather Muller, Aaron Sander, Brett Heike, Jason Beaufort, and Linda Walenta are devastating. My heart breaks for their loved ones who are here in the courtroom with us, and for Holly G. and Andrew S. as well. Still, it is in the grisliest of cases that due process and legal procedures matter the most. Due process requires that the same law must be administered in the same courts for Reginald Carr as for anyone else. Concern that it may not be was expressed by Justice Beyer in Carr 1 more than a decade ago. Hard cases make bad law. We're here today in Carr 3 because the courts keep tinkering with the machinery of death in this case, but no amount of patching may cure the hollow foundation that Reginald Carr's death penalty sentence rests on. Reginald Carr was never sentenced on count 2. That means there is only one way forward. This case must be remanded to the district court for further proceedings consistent with Carr 1.
Counsel, can I interrupt you? And
of course, Your Honor, that's what we're here for.
certainly this court agrees with what you stated at the outset, that due process applies to all defendants. I don't think anyone disputes that. It strikes me that, and I'm going to essentially ask the same question Justice Wall asked earlier, which is this whole notion that he was never sentenced on count 2 seems utterly belied by the last line in Carr 2, which says, we affirm the sentence. Help me. I mean, if there's merit to your argument that he was never sentenced, how is that coming up for the first time now, after we already affirmed the sentence?
Oh, that's a great question, Your Honor. That's a fantastic question, and one that I suspect, if things do not go a certain way today, will be dealt with in Carr 4 on the habeas, right? The question, why did the Carr 2 attorneys not raise this?
Well, maybe they didn't raise it because it doesn't have merit. I mean, that's an alternative possibility, right?
I do not think that's why they did not raise it. I think there was just a failure to raise it.
Okay.
Here's the problem, Your Honor. There's a disconnect between the court's mandate in Carr 1 and the court's mandate in Carr 2. In Carr 1, you sent it back. You sent it back for proceedings not inconsistent with what happened in Carr 1. Under that mandate, the district court certainly had authority to sentence him on count 2. The problem here is it didn't go back to the district court, right? It went up.
It didn't go back because our mandate never became final. There is a higher court that has the obligation and duty to review our findings in Carr 1, and they said we were wrong.
Well, no, what they said, Your Honor, respectfully, is they said you were wrong on 2 points. They
Right.
did not say anything as to count 2.
That's why it came back to us. In other words, there was never a mandate, actually. A mandate in Carr 1 never became final.
But the mandate from the United States Supreme Court was for proceedings not inconsistent with theirs.
It sent it back to us. and
Right.
it Was Carr 2, and
Right.
that Carr 2 mandate is the one that I was asking you about.
But what would have been consistent with Carr 1 with both your mandate and the United States Supreme Court's mandate is for sentencing on count 2. That got circumvented by
Yeah,
the
your-
Supreme
your-
Court coming
Your
in.
argument is we got Carr 2 wrong. That's your argument, right?
I'm loath to place blame at the foot of the court.
Well, but
Uh,
procedurally, going back to the point you made at the outset, that really matters because we're not here to talk about whether we got Carr 2 wrong or not. It's not procedurally postured that way. Would you agree with that?
I agree with that. And I think the problem here was the handoff. Things got complicated when it went to the United States Supreme Court. I think we would all agree on that. The problem here is in coming back, somehow the fact that he was never sentenced on count 2 just got swept under. And Carr 2 moved on and it affirmed a sentence that never took place, right? There's a difference between the conviction and the sentence, right? There's separate proceedings. In this case, there's separate trials entirely. You have your guilt phase and you have your penalty phase. I'm not questioning the conviction. I'm not questioning this court deciding that count 2 was a valid conviction and to move forward on that. The problem is in the sentencing.
You say they got swept under the rug or lost in the shuffle, so to speak, but returning back to the sort of the preservation question, part of that is that was never an argument that was raised to the court. So if the mandate doesn't leave the opening that you're seeking, is it fair to say that you have to find another vehicle to raise these issues to avoid potential preservation problems such as the illegal sentence statute in Kansas or your theory that the ability of this court to notice unassigned error continues even beyond the appeal?
Certainly, this could be dealt with in a different proceeding, right? It could be dealt with on state habeas, right? There could be a claim that there was ineffective assistance of counsel and the Carr 2 counsel by failing to raise it. I respectfully see things differently than Judge Stegall in that I do not see the Carr 1 mandate as having been wiped out by Kansas versus Carr. When the Supreme Court sends back and they say, we're only doing this bit, everything else, that's on you guys. You do what you want.
I see where you're headed. And I think maybe we're maybe two ships passing a little bit. I understand you're not conceding any of your argument that there's there's ambiguity with the mandates, and that is what allows you to assert these theories of error. I'm asking you, if we disagree, are any of your discrete issues raised properly couched as an illegal sentence claim or unassigned error under the Kansas statute, where we could get to the merits of them, even if we disagree with your mandate position?
Yes, I think it's unassigned error. I do not think it's illegal sentence. To be an illegal sentence, we would have to have a sentence, and we do not have a sentence. So therefore, I do not think it can be the former. I do believe it is the latter.
Can I follow up just to really clarify?
Absolutely.
Arguably hyper-technical question about these mandates. I do understand your point that you're saying that the United States Supreme Court did not reach many of the issues that were found in Carr 1. But my question was maybe more technical, which is, I'll put it in the form of a question. Do you think that a mandate ever actually became final from Carr 1? Because arguably it did not, given that mandates do not become final until appeals are exhausted. There was a petition for cert filed. It was granted. The court heard it and remanded it back to the Carr 2 court. So that Carr 1 mandate, I wanted to get your response to this, arguably never actually became final. It's not a thing.
Well, I think you know exactly what I'm going to say, Your Honor, but I will say it anyhow, because I believe that the part of the mandate that was untouched and not taken by the Supreme Court became final
And
at
can
that
you
point.
articulate under our rules how that happened? Because isn't the mandate stayed, the entire mandate, as soon as cert is granted?
Yes, however, once
How did it become final?
it became final, once the Supreme Court remanded for things not inconsistent with theirs, your part that was not inconsistent with Carr 1 was final at that point.
Okay.
I do not think the court needed to again put out a separate opinion that said, we already told you, you need to go back on these other issues. We've already said that, right? So at that point, I'm going to throw out a number that has no meaning here, but just for example, it's not the 10 issues that we already told you to deal with. It's the 7 issues because these 3 were already dealt with by the Supreme Court.
But wasn't the remand from Carr 1 was focused on the penalty phase issue with the joint proceedings during the penalty phase. And that's exactly what the US Supreme Court reversed. So I'm trying to understand what you think was left in those 2 appellate decisions to go back.
I think that when this court sent it back, so you're right, Justice Wall. Here's where it gets tricky, right? When you guys were done with Carr 1, in your mind, there was no death penalty. This was done. You'd wiped it out, right? It's gone. So we do not need to, at that point, say on remand clearly, and you must resentence him. But when the Supreme Court flipped that, it did not suddenly make a sentence appear. It didn't make a sentence that had never been there appear. Judge Clark never pronounced sentence on count 2. And I can go into that and explain why I believe that is absolutely clear and the state's argument is wrong. But first, let me finish answering this. At that point, once it comes back and they've said, no, we're not going to let you get rid of the penalty, the sentence for the reason that you said, it does not change the fact that there still is no sentence, and consistent with your mandate, which was not a specific mandate. Had it been a specific mandate, Justice Stegall, where you said we're only remanding for X, then I think we could have a problem. But that's not what this court did. What it did is it said for issues not inconsistent with, and that's where the sentencing for count 2 is a live issue. It's not inconsistent with Carr 1. It's not inconsistent with the Kansas versus Carr in the United States Supreme Court. So that's an issue that the district court needed to deal with at that point in 2016 following Kansas versus Carr.
Okay. One final question on my sort of theme here. In Carr 2, we characterized the undisturbed decisions from Carr 1 as law of the case. In other words, and so why would we have done that if they were settled by the mandate?
I think the law of the case here is that he needs to be sentenced.
I'm trying to, again, get to this question of whether there was ever actually a mandate under Carr 1.
I think this court was put at a disadvantage by the way Carr 2 was approached.
Well, the U.S., as we've discussed, U.S. Supreme Court reversed on a few discrete issues, and the other issues decided by Carr 1 were undisturbed. And we said those issues that were decided and undisturbed are law of the case. We didn't say they're decided. Doesn't that mean they were decided really in Carr 2?
No, law of the case means that they were decided in Carr 1, but this is law of the case, right? Law of the case is that this court has already decided an issue, and we're not going to decide it again because it's law of the case. When this court decided that counts 1, 3, 5, 6, 7, 8 are out, and we're moving forward on count 2, and there's no sentencing in count 2, that's the law of the case. The law of the case is now we have to make sure that we sentence them on count 2. That's the law of the case at this point. Now, I think, were you not getting rid of the penalty phase, this court clearly in Carr 1 would have said, and let's be clear about what we mean by not inconsistent with. You need to do X, Y, and Z. But at that point, the court did not believe they needed to do that because they thought the issue was already gone. It does not make the issue disappear because it went to the Supreme Court. In fact, it's the Supreme Court that made the issue reappear. That's what brought this back to life. I'm sorry, I'm out of time. I'd like to keep explaining, but I'm out of time. So if you
Go ahead and
Okay.
finish up your.
Here's what happened, right? This all got bungled at the trial court level because they were playing fast and loose with the numbering. And had they not done that, I think we would not be here today, right? That you have an amended information that has 8 counts. 1, 2, 3, 4, 5, 6, 7, 8. 1, 3, 5, and 7 are felony murder. 2, 4, 6, and 8 are multiple murder. When it goes to the jury at the end of the guilt phase, those 8 counts become 4 counts. They become 1A and 1B and so on. So count 1, the felony murder of Heather Muller, becomes 1A. The multiple murder, which was count 2 for Heather Muller, becomes 1B and so on. So you only have 4 counts, but in the alternatives of 1A and 1B. The jury is asked to find on all of those, not as 1 through 8, but 1A, 1B, and so on. And they do. They find them guilty on all 8. That's why this court was able to later say, we're upholding the multiple murder of Heather Muller. Had the court then gone to the penalty phase and said, we're again presenting you with 1A, 1B, et cetera, this would be a lot cleaner. But it did not. What it did is it said, you have 4 counts again, but now there's no A and B. A and B disappeared. So the jury only has 1, 2, 3, 4 for sentencing. We do not know what the jury was finding the aggravators in relation to. We do not know that because they didn't specify. It's just count 1, count 2, count 3, count 4. And even the counts there don't match the counts here, right? Count 2 is at penalty phase was Aaron Sander. Count 2 here, when the court revived count 2's conviction, was Heather Muller. When it goes to sentencing, following them saying we find that beyond a reasonable doubt the aggravators have been met, it goes to sentencing, and now we do not sentence on 1, 2, 3, 4. What Judge Clark does is he sentences on 1, 3, 5, and 7. So now we've gone from 1 to 8 down to 1 to 4 A and B, down to 1 to 4, back to 1 to 8. And he says 1, 3, 5, 7. And the thing that everyone cited in their papers is, you've seen this, right? Transcript volume 113, page 59, where he says, in counts 1, 3, 5, and 7, your sentence is that you be put to death. But I think that's not the really important sentence. The really important sentence is the one right before that. Right before that, he says, first, I'll adopt as my own all the matters set out in the Kansas Sentencing Guidelines Pre-Sentence Investigation Report, face sheet, and all the attachments. And if you look at that, if you look at the Pre-Sentence Investigation Report, which you'll find in the record at volume 158, page 1, it lists only counts 1, 3, 5, and 7. It doesn't list counts 2, 4, 6, and 8. It then specifies under them, name of primary offense, this is count 1, capital murder count 1, KSA number 21-3439, subsection A4. It never says A6, right? A4 is the felony murder that you all got rid of. A6 is the multiple murder. It's not there. It's not there in the pre-sentencing report at all. In each of 1, 3, 5, and 7, they only cite to the felony murder. They do not cite to the multiple murder. Now, they easily could have said A4 and A6, A4 or A6, A4 and or A6, but they do not. They're not merging them at that point. They're not merging them into one. They're only using the felony murder, not the multiple murder. To go to your point earlier, Justice Standridge. So when it comes back and Judge Clark says, I'm sentencing him on 1, 3, 5, 7, that's not a shortcut. That's him going off of the pre-sentence investigation report where there's plenty of room to have added the other things, and he doesn't. Nor does he say, as we've all seen judges do at trial, I am sentencing you on count one, and if count one is ever held to be invalid by a higher court, then count two in the alternative. He doesn't say that either. He just sentences on counts 1, 3, 5, and 7. And under Kansas law, you have to pronounce sentence, and that sentence was never pronounced. For that reason, Reginald Carr does not in fact have a death sentence. And his case needs to be remanded for sentencing consistent with Carr 1. Any further questions, Your Honor?
Any further questions, colleagues? Thank you. Mr.
Thank you.
Lawrence, we'll see you on rebuttal. Mr. Isherwood.
Thank you. May it please the court, Deputy District Attorney Boyd Isherwood on behalf of the state of Kansas. I'd like to comment a little bit on the argument already from this morning. I do think that Justice Wall is correct in that it doesn't appear that anything was left open by Carr 2. The mandate was fairly clear. With respect to the concept that there were all these additional crimes that reversed and somehow the jury was aware of those and infected their decision to impose death or that kind of a situation. I think Justice Standridge is on point with the concept that even if those hadn't been charged, those facts would have come in. And clearly the behavior of the defendant is the behavior of the defendant. There's no thought process that that behavior was false in some way. It really doesn't matter that it also at one point was thought to be the formulation of a crime. It was just their behavior and could have been taken into account in all of the four circumstances, the aggravators. I really don't, also with just.
So are you suggesting then that once you're in the penalty phase, there's really there's no longer that connection to count specific? I mean, the jury is then focusing on the aggravating circumstances, whether they exist, and if so, whether they are outweighed by mitigating circumstances, and the evidence of those aggravating circumstances remain the same for all 8 counts.
That's correct.
Okay.
Also, Justice Standridge had briefly commented on the merger concept, I assume under Vargas, and that is exactly what this court says happens with alternative counts. At some point, there is legally no concept of count 1 and 2. Since they are in the alternative, they merge into one, and neither defendant has made any argument that Judge Clark's comments somehow didn't sentence on count 1. Also, there's been multiple comments with respect to the specter of 1507 type of habeas type of situation, so be it. If these are issues that are better litigated in a habeas context, great. We can do it there. But as this court has indicated, we're here to review the district court's decision. The district court's decision was based upon what he could read from the mandate. There wasn't anything left open to do. That was also the state's position. And the fact that all of these convictions, and there were quite a few, were reversed in Carr 1, is really of no particular moment with respect to the issues we're talking about today. Apparently, opposing counsel was able to go back through and find which convictions were reversed, and from reading the mandate.
As I at least understood the defendant's argument, it was to sort of sidestep the obvious point you're making, in which the court has also noted in questions about the mandate from Carr 2. As I understand the defendant's argument, it is, look, the district court didn't just have the mandate from Carr 2. It also had the quote unquote mandate from Carr 1. And those are, I guess the argument is they conflict with each other or they create an ambiguity. So I wanted to ask the state, you heard my questions to opposing
Right.
counsel, the sort of technical question about, was a mandate, did a mandate from Carr 1 ever become final?
No.
And can you articulate why you think that from what is the law or statutes or court rules that you rely on to come to that conclusion?
Well, I can't give you the statute numbers.
That's fine,
from the
but
podium. But
articulate the legal basis for that.
it's as you said, the mandate in Carr 1 was stayed while the United States Supreme Court reviewed the issue and then sent it back down. And then this court's comments in Carr 2 indicated that.
So your position is, in this case, on direct appeal, there has really only ever been one mandate.
That's correct. Yes.
And that's from Carr 2.
Carr 2, correct. Opposing counsel has not really got into any of the specific arguments they raise other than these kind of general statements. The court is aware of all of the briefs and the issues that are briefed in the briefs. I would open myself up to any of those questions to the extent the court has any specific comments or questions with respect to how they were briefed or anything of that nature. Otherwise, it seems to me that this case is easily resolved under the concept that Judge Gehring looked at the mandate as he is supposed to do and didn't see anything open to continue with. And as far as these statements that there are all of these reversed decision or counts somehow affected the jury's ultimate decision, they were based on the defendant's behavior. And as Justice Standridge pointed out, that behavior was not going to not be considered.
Let me ask you, setting aside the mandate or the scope of the mandate question, is the failure, both defendants' arguments that the failure to sentence specifically on count 2 a viable illegal sentence claim that would have otherwise given Judge Gehring jurisdiction? And was it characterized as such below?
Correct. And in order for it to, it's kind of a weird situation where I think that at some point, maybe you need to litigate the merits of it in order to understand whether it's in fact an illegal sentence. It can't be, I assume, I thought I heard counsel say it wasn't an illegal sentence. But if we're going to open that back up into the concept that it could be an illegal sentence, I suppose under one of the 3 ways that an illegal sentence can be, it would have to be under a court with no jurisdiction. I don't know if that answers the question at all. I can continue with that if you'd like, or unassigned errors, but I'm unclear whether the unassigned errors goes past the direct appeal. And also the unassigned error statute indicates that you can reach unassigned errors, but it doesn't mandate that you do. And so there's another situation.
Yeah, and I just didn't know if the theory that the failure to receive a sentence on count 1 yet have death imposed as a sentence deviates from the statutory scheme or one of the, I understand I'm talking about the definition of a legal sentence can be jurisdiction, ambiguous or failure to conform to the statutory scheme. And I think it's that third theory that I was really asking about.
To fail to adhere to the statutory scheme?
Yeah,
okay.
Or that component of the definition of a legal sentence. Does the defendant's argument fall within that, or does it fall outside that definition?
I would assume it would fall outside of the definition, but just to clarify, I believe you did say count 1. I think you meant
I'm sorry,
count 2.
Yes,
Yeah,
my apologies.
Yeah, the argument with respect to failure to give a sentence on count 2, again, as Justice Standridge indicated, these were alternatives. I do believe that Vargas and the merger doctrine, I think we're done because there was a sentence on count 1. Again, counsel doesn't indicate that there wasn't a sentence on count 1. If you're looking for a portion of the record where Judge Clark says that this is your sentence for count 2, you won't find it. The reason you won't find it is imperative. It's dispositive. Here's the situation. We did start off with eight counts. They were charged in the alternative. The alternative charging is not something that we can just push aside, again, because of Vargas. But they were charged in the alternative. When we get to the guilt phase jury, they were broke out into, there were 4 counts at that point, and they were broke out to way A and B. And importantly, the guilt phase jury indicated that we are going to find, with respect to both means or manners, A and B.
They did find that.
They did. It's
In the guilt phase, both alternatives.
Clearly in the-
were found.
I'm sorry.
Were
Correct.
found guilty. Yeah.
Correct. Now we move forward. And at the sentencing phase, that verdict form, it doesn't matter that there were 2 ways at this point. 10 days before the verdict form was given to the sentencing jury, they just found both ways. Now it just becomes 1 count of capital murder with respect to that victim. I thought I heard counsel, and of course they found that all 4 of the aggravators applied and were not outweighed by the mitigator. I thought I heard counsel comment to some extent on this concept that he provides no authority for, that somehow at the sentencing phase, it needed to be broke back out, and we needed to have this type of unanimity that's not called for by the controlling Kansas statute with respect to, we need to see something like we did at the guilt phase where they say both A and B. That's not what our Kansas statute requires. It requires unanimity. That we had. That verdict form demanded it. The jury discharged that duty by finding so. The United States Supreme Court has indicated that the states are free to articulate the manner in which the death penalty is imposed, as long as it doesn't interfere with 2 things. And one that he seizes on is the 8th Amendment and individualized sentencing. But there's a disconnect between his argument and what he claims is the 8th Amendment violation. First of all, it can't be an illegal sentence if it's constitutional. Secondly, the United States Supreme Court already spoke to whether there was an individualized sentencing. You can read that opinion and it ticks off all of the ways which there was an individualized sentencing. This argument that is being made with this additional level of unanimity that is not required by the controlling Kansas statute is simply a way to try to get into the Marsh opinion that said the states are free to articulate how the weighing and balancing of the mitigators, aggravators with respect to the death penalty. He's just trying to house in there, but he can't. It doesn't have anything to do with individualized sentencing. This was only with each verdict form was with respect to each of the defendants. So I just wanted to get that out there in case it comes up in rebuttal. Unless the court has any further questions, respectfully request that Judge Gehring's decision be affirmed.
Can I just ask
go
you,
ahead.
if that's okay? Thank you, Chief Justice. There are 2 other issues in the briefing that nobody's talked about yet, I don't believe. But one is a challenge to Judge Clark imposing various counts consecutive.
Correct.
As opposed to concurrent. And then there is an argument that the district court judge lacked jurisdiction over certain counts. What do you recommend the court do with those 2 issues? Are they preserved for our review?
Okay, it's a little bit difficult because of the setup we have here. I think those were mainly brought in Jonathan's appeal, and I do think we made an argument that they weren't preserved. To the extent they were preserved or could be reviewed under unassigned error at this point, obviously the abuse of discretion standard would apply and it would be the defendant's burden. I don't think I ever really followed the last part about how running the counts consecutive was illegal. I'm sorry, I can't comment on arguments I don't understand. And on the first argument with respect to certain counts being run consecutive, there are plenty of facts in this case that would allow the district court to run any counts consecutive, and the prevailing statutory authority does not require any type of articulation from the district court with respect to that. This court has indicated in a number of cases that there's neither case law or statutory authority that requires any kind of articulation of the reasoning. And if the argument is, to circle back to the beginning, if the argument is simply that other counts were reversed and somehow that, as one of the defendants put, infected the decision, again, as Justice Standards indicated, these are the facts of the case. And unless this court is prepared to issue some sort of a ruling that the facts of the case can't be taken into consideration when a district court determines that a case should be consecutive to another, I guess they lose.
And were the counts that the district court didn't have jurisdiction over, that those did not impact the sentence imposed? That is your position?
That's correct.
Okay. And, but you did seem to concede one error
With respect to Jonathan, as I was reviewing the record, I'm not strong with math. Math is not strong with me, but I did indicate I saw some sort of a discrepancy in there, and that issue is fully briefed. The result of the issue would be that there's no need for a resentencing. It just needs to reflect the sentence from the bench rather than the journal entry. And I think there was just confusion in that I think it was count 49 had a 7-month sentence, and instead of articulating count 49, Judge Clark articulated count 7.
Right. It's in the journal entry, but not pronounced.
Correct.
From sentencing. Thank you.
Correct. Seeing no other questions, we would again respectfully request that Judge Gehring's decision be affirmed.
Any questions, colleagues? Thank you, Mr. Isherwood.
Thank you.
Mr. Hendrickson, you reserve 3 minutes.
Sorry, I didn't pack up on myself.
So you
here.
take your time.
Gravity's against me.
I did not spend much of my time addressing anything other than the capital
We didn't give
issue.
you much time to do that.
And I don't plan to now. There were errors in it, but I really think I need to spend my time focused still on the capital issue. If the court determines there was a merger, which on counts 1 and 2, then you need to look at what happened. They submitted this to the jury, and they asked the jury to make findings of guilt on murder on 8 different theories. They charged it and read to the jury in the opening that when they read the information, that there was counts 1 through 8, and they denominated different theories of homicide.
Can you articulate why it matters once you move from guilt phase to penalty phase? Why does it matter which underlying theory the state is talking about?
Obviously, we're here on a rather technical argument, Justice Stiegel, but it seems to me that if there was this merger, which we reject, but if there was this merger and he announced a decision only as to count 1, and then the Supreme Court of Kansas reversed half of count 1, we do not know if the announcement of the death sentence by Judge Clark included the sentence that was affirmed.
Making that argument, aren't you assuming that quote unquote count 1 in the guilt phase is the equivalent of count 1 in the penalty phase? I mean, your argument is that quote unquote count 2 disappeared.
I couldn't hear you.
I think your argument is that between the transition from guilt phase to penalty phase, count 2 just sort of disappeared. That's your argument.
Well, it didn't disappear. The judge renumbered it and called it 1B, I guess.
Well, but that was in the guilt phase, right? In the guilt phase, it was
Yeah.
presented as 1A, 1B, or 1 and 2, I'm not sure it matters, but 1A, 1B, and then in the penalty phase, it was just one,
Well,
right?
presumably that's certainly the state's position that,
Well, what else could it be?
well, we wouldn't be here if Judge Clark had said on counts 1A and 1B, it's so forth
But
and
that's
so
why I
on.
asked the very first question, which was, why does it matter? In other words, why would a judge ever say it's count 1 and count B? Because it doesn't matter in the penalty phase.
Well, it obviously matters in this case because,
But why?
well, because he didn't say 1A and 1B, and the Supreme Court of Kansas reversed at least half of that count.
Okay.
And so as a result of that, we now have a speculation as to whether you might be putting a man to death on an announced punishment or an unannounced punishment. And Kansas law requires that it be announced in open court by the court to the defendant before you deprive someone of their life.
But isn't that the conviction is capital murder, right? And I think, in the penalty phase, it was weighing aggravating versus mitigating for capital murder. You found it in both alternatives, but it's one capital murder.
Well, it's obviously only one death occurred, but the state thought it useful to prosecute on two alternative theories, and both were sustained by the jury. And the court made a decision to abbreviate the announcement of punishment which was unnecessary. If he had spent an additional 10 seconds articulating the order, he would have been in compliance with Kansas law. But he didn't do that. And so that's why we're here with, I think, a valid complaint that he failed to announce the sentence of death as to the count that's now presently before the court. He was required to do that. He didn't, for reasons unknown to me. And this court ought to remand this for the first sentencing on count 2, because it's never happened.
Yes.
One quick question, just to follow up on the relief that you're seeking. You acknowledge this is really a technical argument. Are you just seeking the formality of a repronouncement?
No, I did try to address that earlier, Justice Walsh. I think that this should be remanded for a sentencing. I've cited the statute upon which we rely in the brief, and it says that in the first instance, the trial judge will determine the recommendation of the jury and determine if a sentence of death is appropriate. Since that has never occurred on count 2, the surviving count, then I think that some type of proceeding, a meaningful proceeding, should happen in Wichita, in Sedgwick County, to determine what this judge determines as a result of the modified case that he has before him. He has a different case than the one that Judge Clark did. Judge Clark obviously thought it was appropriate to charge the sex crime murders the way he did. He obviously thought it was appropriate to allow the jury to consider 4 counts of murder for killing the same 4 people. You all did not conclude that, and you reversed that. So we have a different case for sentencing now than we had 24 years ago. And so the relief we're asking is a remand for sentencing, because in the view of Jonathan Carr, he's never been sentenced on count 2, the surviving count.
Any other questions, colleagues? Thank you, Mr. Hendrickson, for your arguments this morning.
Thank you.
Comrades, you reserved 7 minutes.
Yes, Your Honor. This is a first. I'm convinced I was incorrect on an answer. In listening to the state and listening to Your Honors, I think I was wrong on the illegal sentence answer. Because under Kansas law, one part of an illegal sentence is one that's imposed by a court without jurisdiction. Essentially, what this court's saying today is, well, he must have been sentenced because we said so in Carr 2. This court does not have jurisdiction to impose a sentence. That has to be done by a district court. So the argument that I'm hearing from your honors is, but we said it, therefore he's been sentenced. It does not change the fact that Judge Clark did not actually pronounce a sentence on count 2, which I've explained, I think is crystal clear from the record here.
I'm sorry, can you help me track through the references to count 1 and count 2? Because as I'm looking at the verdict forms again, count 1, Heather Mueller, this is the guilt phase.
Thank you.
Form 1, guilty of capital murder, Heather Mueller. A and B, jury circles both, if you're done.
Yep.
Now I look at the verdict form from the sentencing phase, and it's count 1, Heather Mueller, death. I don't see the problem. Unless you're just saying that Judge Clark misspoke when he was pronouncing sentence. I mean, there's a lot of complication in this case, and that's been one of my criticisms of it because of the way the state combined the defendants and did all that. There's a lot to straighten out. But when I'm looking at this is what the sentencing verdict form says makes sense to me in light of what the guilt phase verdict form looks like. So, and then you're coming up and saying count 2 is Heather Mueller with multiple killings. That doesn't, I'm not seeing that. Because I'm looking at the verdict forms that the jury did and the sentencing forms, and to me, they're consistent. So I thought I understood this coming in here, but now I'm getting okay.
All right, let me try to see if I can clarify this. I do not think there is anything wrong with the guilt phase verdict form, right? I think it would have been wiser to keep things as counts 1 to 8, and I think it might have avoided some of the problems we're having today. But the jury got a chance to decide individual issues, and they did so. On the sentencing phase, they did not get that same opportunity. Now, I know Justice Standridge is saying, but they're going to see the same facts, right? So what's the difference? Here's the difference. The difference is that while the state says states are free to determine how the death penalty is imposed, that's only to a point. Furman, Gregg, the U.S. Supreme Court says narrowing and individualized sentencing are important. And the problem here is when they lumped it all together, you did not get the individualized consideration that is required under that long
You're
scale.
saying that the individualization requirement applies to whether or not the defendant was convicted of capital felony murder versus capital multiple murder?
I'm saying that when, yes, I am saying yes is the simple answer. Because they have to tie those aggravators to things. Let me try to simplify it.
And you're anticipating my question, but I'll just ask it to be clear.
Okay.
What scenario in a penalty phase would that distinction ever matter?
All right. Imagine this. Imagine first. Well, first let me answer that directly before I give that. Oh, I'm sorry. Here's the scenario. What if juror number 1 thinks to themselves, I'm looking at this and I am horribly offended by the felony murder, right? Rape is an awful crime. And I see the aggravators tying to that, and therefore I'm voting for this. But someone else sees the multiple murder as the issue. Juror 2 sees the multiple murder as the issue that they're tying it to. We do not know which they're tying it to.
That's a unanimity problem, not an individualization.
Well, that's a unanimity problem, yes.
And is that really a problem under Kansas law? And that goes back to my why does it matter question.
Well, let me ask this, let me give you a hypothetical. If we had one charge, no one would dispute that the failure to expressly find an aggravator as to that offense prevents the death penalty, right? Here, it's no different with multiple charges. The jury's required to make findings for death eligibility as to each offense. It failed to expressly make those findings. The prerequisite necessary to impose death did not take place, right?
Isn't each offense the capital murder? It's not
Each
how
offense
the
is-
murder was committed. It's the offense of capital murder,
Each offense is a capital murder.
right?
But to say it does not matter, then what we are essentially getting is a windfall for the state, where if we're saying if they charge enough things and we group it together, they're going to win. Because we don't have to have the jury figuring out the specifics of things.
We do in the guilt phase, and what they decided was capital murder.
Right.
And so then you're looking at aggravating and mitigating circumstances in capital murder.
And those aggravating and mitigating circumstances need to tie to an offense. And this court's now saying there's no
But the
offense.
offense is capital murder.
Well,
I mean, in the penalty phase, they're finding whether they made findings as to the aggravating circumstances that existed. Correct?
correct.
And that would not have changed regardless of the specific count number of capital murder, would it have?
I don't know, because it's a weighing process, right? We're treating the penalty phase as though it's black and white, and it's not black and white. It's a scale. It's a weighing process. And what happened here is in Carr 1, this court took a whole bunch off one side of that scale. But then we're saying, no, it's capital murder, so it doesn't matter. It doesn't matter that there's eight.
But the number of convictions wasn't an aggravating circumstance that the jury could find or consider under the instructions at least.
But certainly, I think it goes to them deciding when they're looking at the aggravators and they're saying, we don't think the aggravators outweigh the mitigators. I think it matters to them how many aggravators there are. Just like, and I understand where Justice Standridge is saying, how we change this doesn't make the rapes go away. It doesn't make the multiple murders go away. These things still happened. But there's a difference when you found them guilty on a certain number of things that maybe they should not have been found guilty on, according to this court, right? According to this court, there were 22 different things that Reginald Carr was found guilty of that he shouldn't have been.
Would you be making the same argument regardless whether count 2 was specifically identified at the sentencing phase? It sounds like you're saying because of the dismissal of the charges, it doesn't matter.
I would not be making the same argument if it was specifically identified in the pronouncement of sentence. If it was specifically identified in the sentencing phase, no, I would not be making the same argument. But it was not specifically identified in the sentencing phase.
I understand that.
And one of the things here.
But you're arguing the impact of the charges that were reversed or no longer before the jury shouldn't be considered. I think that's what you're arguing.
I'm saying that I think it changes the weighing scale in a penalty phase.
Right.
And so I'm not saying they shouldn't be considered. I'm saying it changes how much weight you're putting on things. And here, we already have a situation where we're not sure how much weight they put on each thing because they didn't do them offense specific. And so when you have Judge Clark, who bragged during sentencing that he had 35 years of experience, if he thinks that all they're considering is 1, 3, 5, and 7, which is clearly what he thought based on the entire sentencing he did, why would the jury think different? Why would the jury think? Why would these lay people think that they're dealing with more than that? For some reason, that's all he thought he was dealing with. So I think it's not clear what the jury believed they were determining. And that is a problem. But beyond that fact, a very simple thing here. I mean, if we want to reduce this to its simplest form, and I think in a case this complex, it behooves us to do so, you got to pronounce sentence. And they didn't pronounce sentence under count 2. It's just not there. So we keep trying to shoehorn it in and say, well, no, when he did this, maybe it's this, but this is what I was talking about at the very beginning. This is not dotting the i's, this is not crossing the t's, and this is trying to patch a broken foundation. The simple thing for this court to do, the thing that makes this case proceed on a cleaner and frankly, a quicker path overall, I believe, is to send it back and have him sentenced on count 2. If there's no more questions, thank you.
Any more questions, colleagues? Thank you, counsel, and thank all counsel for their presence and argument this morning. The court will take this matter under advisement